Just before we start, there is an update that the Scottish judge has rejected. You've got that as well. So Jeff was here updating us. So that's one thing we don't have to consider today. Right, let's go to the second session. Professor Hazell and Dr. Haddon, welcome. You've had the advantage or disadvantage of hearing our first session. And perhaps we could start in the same way and just put current affairs to one side for one moment and just ask about your general view on the Act and whether you think it really has made any difference in terms of a transfer of power from the Prime Minister to Parliament, but generally your approach and your assessment of the Act so far.
Could I make two preliminary comments? One is, I think it's early days to sit in judgment on the Act because it's been in force for less than 10 years. And so we have very few instances yet of the Act in operation, although clearly we have a rather dramatic one this week. And so if I may, in my evidence, I'm going to refer to comparative experience in other parliamentary systems which do have fixed-term parliaments, because most parliaments in democratic countries around the world do have fixed-term parliaments. And so it is a pretty normal thing in other parliamentary democracies to have fixed terms. In terms of the advantages of the Act, although it's early days, I would maintain that it has and has the potential to deliver electoral fairness in denying to the Prime Minister the opportunity to call an election when his party is riding high in the polls. It denies the Prime Minister that tactical advantage, and in that sense, as previous witnesses have said, reduces prime ministerial power. It also, this is a small point, but not previously mentioned, can lead to better electoral administration because the Electoral Commission and electoral officers around the country know with greater certainty the timing of the next general election. It can lead in Whitehall to better government planning. That was touched on a little in the first session, but better budgeting and that kind of thing as well, if they have the confidence that a parliament is likely to last for a 5-year term. And finally, it protects the Crown because it removes the Crown from any controversy, as could have happened under the old conventions when a Prime Minister sought a dissolution in possibly controversial circumstances.
I think it's very hard for me to set aside current circumstances with my views of the Act, because my views of the Act have changed even in the last few days, frankly. And I am going to respectfully disagree, though I've not fully formed my view of what should be done as a result of all of this. But I do think that it is now a major problem. I don't think that the problems of the Act, though, are entirely down to the Act itself. I don't think the situation we are in at the moment is because of Brexit and a minority government. My problem with the Act, which I've had to acknowledge, is that its perceptions of it. It is now so closely linked with views of how do we command confidence, what is the role of the Queen, how do we get general elections, and now even prorogation. And this association, and there is confusion amongst political actors as to how it works. Now, some of that could work itself out over time as we get more precedents for its use, as people become accustomed to it. But it is also causing confusion out there in the wider world, and it is becoming more and more associated with these problems. I think we can go into this in more depth, but I think it has also opened up some big questions about the very issue of how do you know if a Prime Minister can command confidence? How does Parliament indicate that to the Queen? What is the Queen's role, and so forth? Many issues which should not and have not been addressed by the Fixed-Term Parliaments Act itself, but it has opened those up. So I don't think we should try and resolve these now in the midst of all of this, but I think it has led us on a journey towards having to tackle more than just the Fixed-Term Parliaments Act itself, and I'm not sure we can revert back to the situation as it was.
I think we'd all agree, Dr. Haddon, that it is quite difficult to just have an academic view of this because of the realities of the situation that we're in. And I just wanted to ask Professor Hazell. I mean, he mentioned electoral administration, easier to plan, but surely our electoral administration should be able to cope with any situation. I mean, it is an ongoing registration, etc., etc. And you also said, Professor Hazell, that it could protect the Crown, but I think, indeed, from what Dr. Haddon was saying, at the present time, this Act is certainly not protecting the Crown. In fact, it could put the Crown in a very difficult position.
Well, just on those 2 points, on electoral administration, I'm not an expert. You may want to ask evidence from the Electoral Commission or from the Association of Electoral Administrators, and they could tell you whether or not I'm right in saying it enables them to plan with greater certainty. It's what I've heard in the past, but I hope you can get an updated view from them. On protecting the Crown, it's certainly the case that there has been some wild speculation about the role of the Crown, but as Dr. Haddon has said, that's based largely on misperceptions. And so I think there is a risk of making the Fixed-Term Parliaments Act a whipping boy for aspects of the extraordinary situation we're in, which, as Dr. Haddon rightly said, is really more down to the fact that we have now a minority government, that Brexit is such an extraordinarily bitter and divisive issue, and that there is a very serious breakdown of party discipline, not just in the governing party, but in other parties in the House of Commons.
If I could just... I haven't really talked about the values of it, and I think from there it's worth actually looking at the values of having fixed terms, so leaving aside the mechanisms for early election, which are a different part of this. And the previous witnesses and Professor Hazell have talked about a lot of them. In terms of planning for elections, I can't either speak to the role of the Electoral Commission. The value to Whitehall and to the civil service in having fixed terms has been touched on. There are many other aspects to that, though, one of which is the ability to prepare for potential alternative governments, which in this country we woefully underestimate what a huge challenge that is for the civil service to have just an electoral campaign, which might be a very short period of time, to then engage with the opposition parties to understand what policies they might bring in. This has an effect on the quality of policies, the ability of a new government to get up and running. We found, the Institute for Government did a report in 2011, and we found that actually many civil servants would value the idea of a fixed term and an understanding that you would have clarity about the sort of run-up period to that. Another part of that is also the opposition, because for opposition parties as well, it is valuable to have a chance to prepare for going into government. And again, this is something that we don't value enough in this country, the effort that needs to be put in, not just on policies around manifestos, but helping potential ministers to understand what the role might be involved. So in theory, it can provide both of those. However, again, this is being disproved by the current circumstances in which we could have an election at any time and the civil service are completely prevented for any engagement with the opposition. So I find myself at a bit of a crossroads in terms of being able to say it is doing the job that it could do.
But are you saying that you support fixed-term parliaments without any mechanism for a change of government in between? Because as long as you have that mechanism, you have the potential for the problems you're outlining.
I think in other circumstances to have a fixed term with a high threshold for an early election is not necessarily a bad thing. I would have to go away and think about them some more. Obviously, in current circumstances, when you have a minority government, you must accept that a government could fall at any time. It's different when there is a coalition government in place. But again, that goes to why the Act was put into place in the first place.
Absolutely, absolutely. And what about the basic principle that this was transferring power to the Commons, with your bigger threshold, you would allow that.
Again, I think that is a direction of travel that you cannot easily reverse. It seems difficult to think that the Commons having, especially again, and I'm sorry to keep mentioning current circumstances, but given the controversies around the degree of power that a Prime Minister has and the mistrust that exists around how they might use or misuse prerogative powers, again, this could change. We could revert back to a position where constitutional norms are respected much more. But at the moment, it seems difficult to envisage a world in which we return prerogative powers to the Prime Minister, particularly this crucial one. So I think it is, at the moment, a foregone conclusion that Parliament would want to retain it.
Well, we certainly can't legislate for respecting norms. Lord Beith, did you want to follow up on this?
Yes, one wonders if the genie is out of the bottle or the toothpaste out of the tube, or whichever of these old analogies best fits. Professor Hazell, you outlined a number of the benefits which arise if the Act can produce a general presumption that the Parliament will last 5 years. And they included the reduction of prime ministerial power, better electoral administration, better government planning. But there is a parliamentary dimension, isn't there? That, for example, the work of select committees and making governments accountable, being able to follow through a series of reports over a period rather than seeing what they can cram in this year in case there's an early election, is a positive benefit in terms of parliamentary accountability, isn't it?
Indeed. Dr. Haddon reminded us about the benefits for Whitehall and also for the opposition, and you rightly remind us about the benefits also for Parliament of having fixed terms and therefore being able to plan for the whole of the fixed term. And we saw that, I think, in the 2010-2015 Parliament. We certainly haven't seen it in the last 3 years, but I would say that's as a result of Brexit, not a consequence of the Fixed Term Parliaments Act. And Brexit has made it impossible for Whitehall to do any serious planning or indeed any serious work on anything other than Brexit. And so please let's not blame the Fixed Term Parliaments Act for the many travails that Brexit has inflicted upon the government and indeed upon Parliament. Brexit makes it extraordinarily difficult to plan.
Dr. Haddon, you did indeed amplify potential benefits for the conduct of government and the operation of the civil service. And that's based, is it on what you've been able to pick up from people within the system, that the degree of predictability which people thought the Fixed Term Parliament Act was going to give them did actually make it possible to govern better?
Yes, I think so. At least it, given the onus that we place on the civil service to be the continuity between governments, we have to accept that they must have some opportunity to prepare for that change of government. And that involves a certain degree of trust, that in doing such preparation they are not looking ahead to a future government and starting to sort of do the work for them that they would do if that government is then elected, but it is about long-term planning for how they as a civil service can adapt in the future. And this has been accepted by multiple prime ministers, why they have repeatedly allowed the civil service opportunities to engage with the opposition. I think the more that we can recognise that that is a valuable thing, and the more that it is, as it were, an expected part of the period, perhaps it's 6 months before an expected general election, the easier it is for the civil service to do that whilst also continuing to serve the government of the day. All that aside, it's worth remembering, as it came up in your previous session, in the run-up to an election after a 5-year term, before even the Fixed Term Parliaments Act came in, you would often see a tailing off of not just legislation but also activity within government, and that has often allowed the civil service the space and time to do this kind of preparation because they're not necessarily as busy as they would be at an earlier stage in that Parliament.
Thank you.
Baroness Coulson.
If we may now turn to the issue of confidence, what has been the effect of the Act, would you say, on the notion of the House of Commons now having confidence in a government?
As previous witness said, formally now there is only one kind of fatal confidence motion, and that is the statutory motion set out in the Act, that this House has no confidence in Her Majesty's government. But it doesn't prevent the government from declaring that other issues will be treated as a matter of confidence, and I would suggest that we saw that yesterday in the vote when the Prime Minister made it quite clear that he expected all Conservative members of Parliament to support the government in that crucial vote, with disciplinary consequences if they failed to do so. So the Act didn't prevent the Prime Minister yesterday from declaring that something would be an issue of confidence. And Prime Ministers still have, I would suggest, plenty of other weapons at their disposal to encourage, cajole, or in other ways persuade their supporters in Parliament to support a particular measure.
I would agree. I think the maintaining the confidence of the House is, as the Cabinet Manual says, central to the government's authority to govern. You cannot get away from this, and it has to mean something more than just the mechanism by which we get an early election. So I have been arguing throughout the lifetime of the Fixed-Term Parliaments Act that the concept of confidence ought to still exist, and it should still be there in other kinds of confidence motions. I'm not sure whether the previous session touched upon it, but another issue is whether a vote of confidence that is not worded under the Act should still have that same weight. And I find it very difficult to believe that if the Commons put forward a motion that said we have no confidence in this government, we wish a new government to be formed under person X, I find it difficult to believe how the Queen could not pay attention to that, and that it should have some force somewhere in our system. I completely agree with Professor Hazell that I think yesterday, despite a lot of discussion about whether during Theresa May's premiership other forms of confidence existed, I think yesterday's vote, the fact that the government declared it a confidence matter, shows that the convention still exists and is still useful to governments as a means of trying to threaten, in their case, unsuccessfully. I think the issue is that the Act has affected what a Prime Minister can do after that. They cannot unilaterally say, I will call an election. They can say, I will put down a vote for a general election, but as we may see in the next week or so, that doesn't mean that you can get that vote passed. But there is another aspect which isn't being discussed at the moment, which is that a Prime Minister can always resign. If they do not have the confidence of the House and believe that their situation is impossible and they cannot continue, they can resign and call for the Queen to call for a successor. But again, it is politics is the reason why the current Prime Minister will not, I assume, countenance that. It is nothing to do with the Act. They still have that ability.
Okay, so is the effect of all of this to strengthen Parliament over the government, in that if you cannot now make a vote, a policy issue, a matter of confidence, does that hand powers to the Commons that they didn't have before?
Yes. It reduces prime ministerial power. We've touched on that already. And it strengthens the role of the House of Commons in deciding whether or not Parliament should be dissolved. And if we are coming to the two-thirds majority required, that is the stipulation in our Act. I referred earlier that we've done a lot of work on how fixed-term Parliament legislation operates in other countries. It's actually quite rare in other countries to have a higher threshold for what we might call a voluntary dissolution, namely a dissolution sought by the incumbent government, rather than a dissolution forced on it by a successful no-confidence motion. But in many of those other countries, there are other mechanisms to try to ensure that there is cross-party support. For example, in some countries, the motion has to be signed not just by the Prime Minister, but by the Leader of the Opposition, or in some cases the leaders of 3 parties in Parliament, to signal strong cross-party support in terms of a wish for dissolution. There are also in other countries restrictions during the term of a Parliament when dissolution might be voluntarily sought. Often at the beginning of a Parliament you cannot seek a dissolution in the first year. Quite often towards the end of a Parliament you cannot seek a dissolution in the last year because an election will be pending at the end of the fixed term. So in other countries there are restrictions of those kinds. Our 2/3, as I say, in comparative terms is unusual, but essentially what I understand it to be there to ensure is that a majority government, not like the present government, but let's think, for example, of one of the Labour governments led by Tony Blair or Gordon Brown between 1997 and 2010, it would have ensured that they could not have unilaterally called an election relying simply on the support of the governing party. They would have had to get the support of at least one other party in the House of Commons, despite their big majorities, to get the 2/3 threshold required.
If it's possible now for a majority of MPs to hold confidence in the government, while it's impossible for there to be a majority to deliver the most significant government policy, how can that be sustainable?
Well, one would think that it is not, and that is the dilemma that we find ourselves in the moment. But that I don't think is down to the Fixed-Term Parliaments Act. I think that is down to a combination of a minority government, but also the particular dynamics around both the policy and the arithmetic in Parliament. But it all comes down to whether or not you have a majority. It does not feel like it should a sustainable position to have a government in power or in office but not in power and to maintain in that role. But again, this comes down to whether or not the politics and the arithmetic between the parties can find a solution. I think whether it was a simple majority that was required rather than 2/3, that could still be a problem. I'm not sure that the Fixed-Term Parliaments Act is the root of that particular issue that we're in at the moment.
Turning to the provision about the 2/3 majority needed, Professor Hazell has spoken about other systems and other ways of dealing with it. I would be interested to know what you think would be preferable. Would you like to keep the 2/3 as it stands? Would you like to introduce, if you could, elements that you have seen in other countries?
I think for now, yes, I would like to see the 2/3 retained. As I said at the beginning, it's very early days to sit in judgment on the Fixed-Term Parliaments Act. What I see the 2/3 ensuring is that the government of the day, even if it's a majority government, is very unlikely to have 2/3 of all the seats in the House of Commons, and therefore, if it wishes of its own motion to seek an early dissolution, it has to get the support of at least one other party in Parliament. Now, Professor Norton rightly said that in effect gives a veto to the opposition or the government's own backbenchers. I see nothing wrong in that. I think it is very desirable, if the government wants to seek an early dissolution, that it has to obtain some cross-party support. And that's what the different mechanisms in other countries, in different ways, in effect, also provide.
So that is sufficient on its own. We don't need to borrow from these other countries that you have been mentioning?
Well, in my written submission, I give a bit more detail about practice in other countries, and if the committee gets interested in this, I can easily supply further detail. It's in a 40-page report that we published in 2010, so that's where all the comparative evidence is. But forgive me, I won't labour you with it today in my oral evidence.
Okay. Dr. Haddon?
Yes, I will defer on the issue of two-thirds because I can see that there are benefits to it of retaining cross-party support and also difficulties in terms of the high threshold that it places on any such decision. I think, though, again, we've come to another flaw in the Act that is not catered for us and which we're talking about at the moment, which is the possibility of a government bringing in a short notwithstanding bill that just sets it aside. And once, again, it goes back to the tube of toothpaste. Once that is open and governments are increasingly aware that they could just do it themselves if they've got a majority, then they might just start setting it aside all the time. In certain circumstances, I think in some, it is valuable to an incumbent government to make sure that the opposition are also agreeing to a general election if they're worried about the consequences of the general election in terms of, the public not wanting another general election. It is useful to co-opt the other parties in that way. But in other circumstances where the opposition don't want a general election but the incumbent government do, and they have enough of a majority, they are probably going to start using notwithstanding bills if Fixed-Term Parliaments Act continues. But I'd be interested what Professor Hazell thinks about that.
Could I just add one other thing? And that is that in the other countries that we've studied, it's very rare to find any complaint that the fixed term is excessively rigid. In all those countries there is, with one exception, Norway, there is provision for early dissolution. And so, in effect, what fixed-term legislation creates is a norm. It doesn't create an excessively rigid framework. It creates a norm and expectation that parliaments will normally last for the duration of the fixed term. And we don't yet know whether at Westminster we have a new norm. As Dr. Haddon has said, a government with a majority could easily circumvent the Act by introducing emergency legislation which says, notwithstanding the Fixed-Term Parliaments Act, the next general election shall be held on a date next month. And that would be, in effect, breaching the norm. But at the moment, we have, I hope, the norm of fixed terms in our Fixed-Term Parliament Act.
But don't we previously have a sort of norm in that, although the maximum was 5 years, it was very unusual for any government to go to the wire?
On the whole, again, it's in my written submission, the history of the duration of parliaments at Westminster, I think since 1945. And from memory, there were 5 parliaments that went to the wire, as you say, lasted for 5 years. In most of those cases, it was because the Prime Minister, who might otherwise have gone after 4 years, was not doing very well in the polls at the time, and so decided to hope for luck to change.
That's politics, that's reality.
Yes, and in most cases that didn't happen. But can I just mention one other thing to remind the committee about what I recall from the previous situation, pre-2011, which was the debilitating effect when we had a maximum of 5 years, but we didn't have a fixed term, which was that from about year 3 onwards, there was speculation about whether the Prime Minister would call an election next year or in the next 6 months. And I was then a civil servant in Whitehall, and it was quite debilitating for us in terms of our planning, because there was this will he, won't he speculation, and it made planning more difficult than if you have a fixed term.
I'm not sure most politicians would accept that, but that's a personal view. Lord Wallace.
Yeah, we talk about the 14 days following a defeat in a no-confidence motion. What do you view to be the constitutional and legal obligations of a Prime Minister that's lost a no-confidence vote? And in addition to that, when do you think the caretaker convention should kick in? Should it kick in on the moment of a loss of a no confidence vote, or 14 days elapsing and there's going to be no vote of confidence in an election at that point? But also, just what are the constitutional requirements of a Prime Minister during that period?
May I go first? Mm-hmm. I think there is less ambiguity than perhaps some people believe. The duties on the Prime Minister are very clear if he's lost a formal no confidence motion under the Act. First is to remain in office. There will probably be calls in the press on the following day for the Prime Minister to resign. But as, again, previous witnesses have said, we must always have a government, and therefore we must always have a Prime Minister. So on day 1 or day 2 of the 14 days, he must remain in office, and he can seek to restore confidence in his government, because there will be a reason for the successful no confidence motion. It might be a reason of policy in current circumstances. It might be because his government is clearly heading for no deal, and the House of Commons, in effect, will have pulled an emergency brake to try to prevent that. And the Prime Minister, in those circumstances, could say, all right, I hear this very strong, clear message that you have given me, and we will now reverse the policy which led you to vote no confidence in my government. So the Prime Minister remains the incumbent Prime Minister, and I think he, in effect, has first crack at seeking to re-establish confidence in his government. He may not choose to do that. He may, as Lord Norton said, seek to sit out the 14 days, and then Parliament would be dissolved, leading to an election. If he were to do that, then I think it is open to the House of Commons during the 14 days to seek to establish whether an alternative person could command confidence. Now, that might be an alternative person from within the governing party, or it might be from the opposition or another party. And the House of Commons has various means, if it could identify such a person, to signal to the palace and to the public that they would have confidence in an alternative Prime Minister. And if they clearly signal that through a resolution or through a motion on a humble address or through an early day motion, then I would fully expect that the incumbent Prime Minister would tender his resignation and would recommend to the Queen that she appoint the alternative who had been identified by the House of Commons. That much, I think, we can state pretty confidently. It is true that the Act is silent about what might happen during the 14 days, but as I say, I think we can anticipate the kinds of things that could happen. Lastly, you asked me about the caretaker convention. That would be triggered as soon as the no confidence motion had been passed. The incumbent Prime Minister would become a caretaker Prime Minister, and therefore there would be the restrictions set out in the Cabinet Manual on what he and his government could do in terms of initiating new policy, making senior public appointments, letting government contracts, etc.
Yes, I agree with Professor Hazell that I think the immediate onus and opportunity is on the Prime Minister to certainly to stay in post, because you must have a Prime Minister in place, and that opportunity to be able to go and see if they can regain confidence or whether form a new agreement with other parties or whatever the situation requires. I think you can also then have moves in parallel for an alternative government. And this is the tricky area, because this is the political resolution that the Act basically requires, and why the Act is silent, because it has to remain in the realm of politics. The controversy that has been discussed in recent weeks, and potentially exists. Again, it goes back to whether or not constitutional norms are accepted. But the controversy is if the Prime Minister, the incumbent Prime Minister, refused to resign despite an alternative government being in place and despite it being clear that the incumbent Prime Minister was not likely to be able to pass that second motion of confidence. And there we are wholly dependent upon a constitutional convention, which is about the legitimacy having lost a vote of no confidence, rather than a legal interpretation of the Act, which is what some have been trying to argue is all that exists. And I firmly do not believe that it does, and I think we need to keep reiterating that point. In terms of the restrictions that are then on a Prime Minister, essentially they have lost a degree of legitimacy, having lost a vote of no confidence. And even though they might then regain confidence, during that period they ought to abide by restrictions. But again, this is a convention. It is one that's mentioned in the Cabinet Manual. But that does not have any justiciable force. So it is reliant on actors involved respecting it. But I believe it's fundamental, and I think that it is another area where increasingly we will ask, should this be firmed up? The principles around caretaker governments in this country are still very reliant, not even just on constitutional convention, but on a sort of expectation of it being customary, is the phrasing that is used in the guidance, and that is possibly too weak at this stage as a restriction in those kind of periods.
Brianna Stray.
Professor Hazell, Dr. Fox in her evidence said that she thought paragraphs 2.27 to 2.29 in the Cabinet Manual were pretty clear in how the Caretaker Convention kicks in. But in your own written evidence, you say the Convention isn't sufficiently clearly explained or articulated in terms of the restrictions on government activity. Without going into too much detail, what would be your top one or two areas where you think there is a lack of clarity?
Well, one would be, I wish they would call it the Caretaker Convention. For reasons I've never wholly understood, the Cabinet Office are reluctant to use the term caretaker because they think it implies some kind of weakness on the part of a caretaker Prime Minister. We've all used it this morning, and in other Westminster countries it is the normal term to describe a government which doesn't command the confidence of Parliament and therefore is subject to certain restrictions in terms of the kind of new policy that it can initiate. What the Cabinet Manual talks about is purdah, but in so doing I think it risks confusing two things, because purdah can apply when a government does command confidence. For example, when there are local elections, purdah applies in terms of what the central UK government in Whitehall can do in terms of making policy announcements and the like, in order not to try to obtain an unfair advantage in those local elections. And so I think it's helpful to use two separate terms to distinguish these two separate concepts.
They could both apply simultaneously, couldn't they?
Mm-hmm. Indeed, and they sometimes do.
Well, you have a situation where you have an announcement on public expenditure on the day that the Prime Minister is trying to call the general election. So purdah only kicks in at a certain point in the day. Brianna Stray, do you want to move us on?
If I may. In your view, what activities can the civil service undertake during the 14-day period? And is there a kind of variation on what they can do if there are circumstances that particularly require redress or urgent action?
First?
Sure. The similarities between the purdah period, or a period of restrictions on government activity as it's often called, and caretaker are somewhat similar, but they are very different. But what is true in both cases is that government does remain in power, ministers remain in post, and they need to have the ability to act in emergency when required. So I think in that respect, depending on the circumstances, the civil service working on behalf of ministers have to be able to do what we might call essential business, urgent business, anything that can't be delayed. In terms of the latter, if one was talking about some kind of emergency across any number of different issues, where the guidance and where previous convention has fallen is to say that ministers in those circumstances should consult with their opposite numbers. Certainly in the period in the run-up to a general election, I think there's a case to be made that in the 14-day period that also should be true, that action should somehow be worked out across party lines. Again, it depends entirely on what kind of scenario that we would be talking about. I'll let Professor Hazell come in.
May I give two examples to bring this home? One is, I think it's right that in 2010, towards the end of the election campaign, there was an emergency meeting of European finance ministers to discuss a Eurozone crisis, and Alistair Darling, as Chancellor of the Exchequer, went to that meeting. But quite properly, he consulted with George Osborne, then the Shadow Chancellor, about the line which the UK government would take, because the Caretaker Convention applied. He didn't want to tie the hands of a future government, and so he consulted with his opposite number. Another example of an emergency, I think this is right, was that the ash cloud, which stopped a lot of air traffic, happened during an election, and I think the then Secretary of State might have been Andrew Adonis. So that's the kind of urgent action that is required, and government ministers will normally consult their opposite numbers about the response that they take. There is in the Cabinet Manual provision in paragraph 2.33, if senior officials believe that the incumbent government in a caretaker period is not observing the convention, they can seek a ministerial direction, which is the way in which senior officials can, in effect, say formally to ministers, we think that what you are doing is improper, and therefore we are requiring a written direction from you instructing us to do this, because what we think you are asking us to do is wrong. And exceptionally, paragraph 2.33 provides, and I'll just read you, if I may, the relevant sentence, during any period when Parliament is prorogued or dissolved, if the occasion for any such directions arose, taking account of issues of commercial or other sensitivity to the direction, together with the reasoning provided by the accounting officer, should be made public immediately by the department and laid before both houses at the first opportunity after Parliament meets. So this is a senior official, in effect, blowing the whistle, but if it were to happen during an election period, blowing the whistle publicly. And that is, yes, and that is the main safeguard that the Cabinet Manual tries to provide if a minister in a caretaker government seeks to do something which officials believe breaches the Caretaker Convention.
There is one difficulty in terms of the 14-day period as opposed to a period preceding a general election, which is that we focus on essential business must continue, and what must not happen is new action of a continuing or long-term character. Now, obviously, you can wrap into that major policy decisions that may or may not have been continued. During the run-up to a general election, one of the key aspects of PERDA is to make sure that government resources aren't used for electoral purposes, and that often focuses on the role of government communications. Now, I'm not sure. I think it would come down to interpretation, and which is why it's important to think about the role of directions, because those interpreting it might in the first instance be civil servants as to whether they think it proper or not. But I think it would come down to interpretation, whether a government campaign of information about preparation for no-deal exit should continue during that period, given that that is quite an essential activity to undertake. the style of the campaign, the cost of it, and so forth might be areas in which you start to call it into question, but nonetheless some kind of communications is arguably essential whilst no deal remains on the table. That is very different. Exactly, that is a very different circumstance if we hit a general election restriction on government activity, because in that case it is going to be in conflict. It may continue to be essential business, but it is going to be in conflict with those restrictions on government activity which are about making sure official resources aren't used in improper manner.
No, please.
On this sort of more precise or narrow issue of supporting the formation of a new government, that activity during this period, 14 days, what do you believe the civil service could do, or could be allowed to do, to support the formation of a new government during that period?
It would be up to the parties in Parliament, if they wanted, to ask the Cabinet Secretary whether they could have support. One example might be what happened during the coalition negotiations in 2010, when the Cabinet Office was very ready to provide support to the Conservatives and Liberal Democrat negotiating teams. But if I remember correctly, Lord Wallace can correct me if I get this wrong, the parties in fact needed very little support other than the provision of rooms and tea and coffee and the like.
They prepared during the election period briefings on policy points. They didn't sit in any of the negotiations, but we did have available, my recollection is we did have available briefing material and would answer questions if there was a specific question. So it was a bit more than tea, coffee and biscuits. And
Thank you for reminding me that they did provide more support. And what I remember was that I think the then Cabinet Secretary was quite keen for officials to be in the room, and that was something that the parties didn't encourage.
Having negotiated a coalition in Scotland, that I said it was not helpful.
Yes, but during the 14 days, the clock will be ticking very fast. And my expectation would be that there would be, potentially anyway, very intensive negotiations between the parties without necessarily very much time or opportunity to consult the civil service, save possibly on a very few items. It might be costing some very controversial big item of expenditure which one party wanted and the other didn't. It might be that kind of thing.
Aspect of the 14-day period, and that is the role of the sovereign. Could you sort of set out a scenario as to how the Palace and the House of Commons might work in tandem, or what would actually happen?
Partly, I hope answered this in answer to a previous question from Lord Wallace. So let me briefly recap. If there is a successful no confidence motion, the 14 days starts to tick. The incumbent Prime Minister remains in office because we must always have a government. He has the opportunity to seek to re-establish confidence in his government. He may choose not to try to do that, in which case it's open to the parties in the House of Commons to see whether an alternative candidate might be able to command confidence. And if they can identify an alternative candidate who could command confidence, they can signal that in a number of different ways, through passing a resolution, through an early day motion, or they could communicate it to the Palace through a motion on a humble address. And that, in effect, would invite the Sovereign to appoint the alternative person as Prime Minister. In those circumstances, I would fully expect that the incumbent Prime Minister would offer his resignation, and recommend to the Queen that she appoint the alternative who had been identified by the House of Commons. And to answer a question asked by Lord Wallace in the previous session, if quite extraordinarily the Prime Minister refused to resign, then the Sovereign has the power to dismiss the Prime Minister. I don't anticipate it would ever come to this, but there's no doubt that the Sovereign has the power to dismiss the Prime Minister as well as to appoint, and in those quite extraordinary circumstances, if the Prime Minister refused to resign, and the House of Commons had clearly indicated that they had confidence in an alternative, I would expect the Sovereign to dismiss the Prime Minister and appoint the alternative.
Explained that very clearly. I was thinking more of what informal contacts might be made through the Cabinet Secretary, private secretaries at the Palace. Would there be, I hesitate to use the word underground, but a very informal explanations to the Sovereign of what was going on?
That is what happened during the 5 days after the 2010 election, when the coalition government was being negotiated before it was formed. And we know, this is no secret, I think, that the then Private Secretary in the Palace, Christopher Geit, was in very close touch with the Cabinet Secretary and with the Private Secretary in Number 10. They are the Golden Triangle who conduct these informal communications, and they keep each other very closely up to date, so that the Sovereign is always informed. But you may remember, over the weekend after the 2010 election, the Queen announced that she was going to be spending the weekend in Windsor, which she did, and that may have been her plan all along, but it was, I think, made public that she was spending the weekend in Windsor, and that in a way was possibly her way of signalling this is a matter for the House of Commons, the newly elected House of Commons, to sort out. I am going to remain at one remove from the negotiations until the newly elected House of Commons can make it clear to me who can command confidence in the new Parliament, so that I can then appoint that person as Prime Minister.
I think it's very important to emphasise that final point, that the Queen, during all of this process, is effectively listening to what is going on and being as well informed as possible, and that is the role that officials play in finding out and understanding that. It has to be kept distant from her. I don't think you cannot have a situation where the Queen, or even perhaps her immediate officials, are having to be dragged into those very negotiations of, would you accept this or that or whatever. I think it is down, if there is a requirement on the House of Commons to find a mechanism to clearly indicate who might have confidence, then it is up to the House of Commons to innovate and find that mechanism. This goes to the area again of where I don't think we can go backwards. Previously it was possible for a sort of assumption about who might have confidence because they sort of said, well, I think I've got the numbers. And it is possible in our Constitution to say, appoint me as Prime Minister and give me a chance to prove that I have confidence. There are many examples in our history where Prime Ministers have done that. But it's becoming harder and harder to find a means to do this, which is why the whole issue around who is likely to command confidence has become more difficult, and we may inexorably be moving towards a more formal system of how that is established in a variety of different circumstances.
But there are options there.
There are plenty of options in many countries who do it very successfully.
Lord Wallace, do you want to go on to the future?
Maybe looking to the future, and there's going to be a review. Just what I think if I've understood you, you both think that there's merit in the concept of fixed terms, jury out, or on this particular piece of legislation. But if this piece of legislation was to be amended, what would your principal candidates be for amendment? And incorporating that as a bit of an addendum, given that we've had a recent controversy on prorogation, and the Act expressly preserves the royal prerogative in relation to prorogation, do you think if there was an amendment bill brought forward it would be an opportunity to review again the prerogative in relation to prorogation.
Yes, I do, in answer to the last point. And in my written submission, it starts with 4 suggestions about small amendments, and the very first of those 4 is the power of prorogation. So I think that should be put on the same footing as the power of adjournment. In effect, I would like Parliament, the House of Commons, to have a say on whether it should be prorogued, and not leave that any longer simply to the Prime Minister to advise the Sovereign. Coming to your wider question about possible amendments, as I said at the start, and forgive me for repeating this, I do think it's very early days to sit in judgment on the operation of the Act, and so I would be quite cautious about proposing amendments. I think if we were legislating afresh, as I said very strongly at the time, I thought it was wrong to go for a 5-year fixed term because the norm in most parliaments since the war at Westminster has been for a parliament in effect to sit for 4 years. But it may be that it would be now difficult to revert to a 4-year term as the norm. We've also discussed the silence in the Act about what would happen during the 14 days, and I wouldn't propose any amendments in statute, but in terms of the various mechanisms that we've described, if an alternative candidate could be identified by the House of Commons who could command confidence instead of the incumbent Prime Minister, it's important for the Commons to be able to indicate clearly who that alternative candidate is and to say that they would have confidence in that alternative person so that the Sovereign could then appoint that person to formally demonstrate that they could command confidence within the 14 days. But I would suggest it would be preferable for any new procedure to be in standing orders of the House of Commons rather than any kind of statutory amendment. And Lord Wallace, you will know very well that in the Scottish Parliament there is provision after an election or indeed following a mid-term dissolution for the Scottish Parliament in effect to hold an election as to who should be the new First Minister, and the presiding officer then communicates that name to the Queen for the Queen formally to appoint that person. But the procedures for the election of the First Minister are all set out in the standing orders of the Scottish Parliament.
My view is that it's still developing my view on all of this, and I think partly for the reasons that Professor Hazell has set out, that it is perhaps too early for this Act, but actually from my point of view, as I said in my opening comments, it is largely because there are so many other issues that I think we now have to think how to tackle, with which Fixed-Term Parliaments Act interacts, and therefore I'm not sure we can tackle one without the other, and I don't think we are in a position to tackle these other issues yet, or certainly not in current circumstances. I think that the concept of fixed terms is fine, and if that can be maintained, that is great. I think that actually the 2/3 motion, particularly given that it can interact with a notwithstanding bill, I think is fine. It provides 2 mechanisms for a Prime Minister to challenge or co-opt the opposition into calling for a general election. I think that it is the 14-day period is the most difficult, and I thoroughly agree that it should remain silent. You cannot put, or at least we can't at the moment, the specifics of how governments can be formed and how to command confidence onto the statute books, and we should not do it rapidly and with undue haste and without any great thought, because we will just create so many greater issues for ourselves. And I agree that actually standing orders might provide a degree of certainty to Parliament that they're looking for what should happen during that period. But again, all of that is dependent on constitutional norms being respected, and therefore, if you have a situation where statute is in tension with the standing orders of the House of Parliament, that is yet another clash between executive and legislature that I would very much like to avoid.
Thank you very much. I think your point about constitutional norms is something that we would all accept as very pertinent. Thank you for staying with us for a little longer than perhaps we anticipated, and thank you also for the written evidence that you've suggested, that you've sent us. So, thank you.
May we wish you good luck with your inquiry.
Yeah.
This is
Thank
very,
you.
very
We
important.
may need it.
Very timely.
Indeed.